contrast on notions of justice between modern Western law and Islamic law. I am not an expert in Western law. Many of you are. And so the best thing I could offer is to present Islamic law in such a way that particular contrasts become evident, on the basis of which maybe we can have a discussion. I'll try and leave ample time for the discussion. Now, what's the advantage and point of such a comparison? It is very, very difficult to claim one such legal code is more just in all aspects. That's a very tall order. So then what's the point of this comparison? I see it as follows. There's a scene in Back to the Future 2, which stuck in my mind since I was young, actually. And the particular scene is when you always get your first introduction to time travel, and always this plays on your head. The Terminator one, I could never figure it out, how you can kill your dad and be alive. But Back to the Future 2 had a very interesting theory, which was Marty went back in time, but something strange happened. So when he went back to the present, he didn't recognize it. It was all confusing and lawless and everything else. And the doc explained to him, you have to go back to the exact point where something changed, so you can return to the timeline that is familiar to you. That idea has played on my mind as an example of knowledge traditions. We all, as objective as we will ever try to be, we are always influenced by knowledge traditions based on particular histories. If I was to say a word like theocracy, which I describe Islamic law with great difficulty, for reasons I will explain, but we all have a very immediate, knee-jerk reaction to that's not just, that's not what we're looking for. But there's a trajectory that took us to that knee-jerk reaction. And it was to do with the history in, perhaps you could say in Europe, a particular power relation the church had with knowledge, a particular set of wars that religion was a part of, and a particular solution that came up by taking religion off the scene. We're on a trajectory. The problem with trajectories is that sometimes it's very hard to imagine a different way to think about being a human being. Because law, as I wanted to share with you, it is about being a human being, more than it's about anything else, as I'd like to say. So it's the hardest of all things to break out of oneself, break out of one's tradition, and reimagine something. It's very, very difficult. But one of the easiest ways to do that, and I think one of the most important ways to do that, is what we're trying to do today is learning from other traditions. Learning from other people who didn't have that history. There are many people in the world, many traditions, ancient traditions in the world, that didn't have laws of religion. That didn't have a religious tradition that was controlling science, or didn't have the things that happened here in Europe. And so sometimes, although we can't imagine that, they can, other people can. And so the point of this comparison, I'd like it not to be merely academic. And like I said, arguing superiority is a very difficult and tall order. But I'd like it to be just a point to reflect upon particular features we take as a given, but they don't have to be. And there are very different ways we can think about being a human being in the world. And that's what I'd like us to focus on in the few pointers I'd like us to be as a focal point for comparison. Now, there's no such thing as an exception-less tradition, meaning if I say Islamic law had X feature, you'd say, yeah, but Y happened in X period. So the idea is exceptions are in all traditions. So when we compare traditions, we compare what we might call a paradigmatic statement, which is Hanif's favorite statement when he does these comparisons. Hanif is an interesting author. Some of the points I'll be sharing are just developing things that he said about the fact of, because we'll be talking about politics a lot today as a point of comparison. So he compares what he calls the paradigmatic Islamic tradition versus the paradigmatic Western tradition. And in fact, he argues something which I'll be hinting at, which is that the paradigmatic Islamic cannot exist in the paradigmatic modern. And that's why his very contentious book came out in 2013, I think. It's called The Impossible State. And what he means by that is it's not possible to have a paradigmatic Islamic governance within modern Western states. Not because Islam is anti-Western, but because there's features in the state which are completely at the opposite of what the Islamic tradition is interested in preserving. And it's those features which will be quite key in my comparison. So we're discussing paradigmatically, but definitely the paradigmatic is something whose norms are much greater than its exceptions. It's historically borne out, the features I will be stressing. Now, when it comes to discussing justice, justice is at the end of the day, justice is about fairness. It's about people being treated fairly, equally, with rights we think they ought to have. There's no system of law that would set out to be unjust. But what you find in legal systems is, as you go through their cases and their scaffolding, you stumble upon their priorities. And it's the priorities of justice I'd like to be focusing on. I'll be discussing themes to do with loci of power. I'll be saying that in our modern Western, and you guys can correct my terminology at the end, just to talk about what we know now, as opposed to pure Western, which, although it means the modern Western, I don't want to make a judgment on West versus East, but what we recognize now, I'd say the locus of power is very much in government and state, and I'm going to contrast that with an Islamic theory of law, where the locus of power is much more in community, and I want to explain what that looks like. And that's at the heart of why an Islamic law is impossible in this framing. Well, not in reality, but as we can see. I want to, as I contrast things, and we look at priorities, I'm going to be making a very odd assertion as well. I'm going to be saying that freedom is one of the greatest principles of Islamic law. Freedom from state, freedom from control, freedom where law is actually to protect people from government as much as it is to present a theory of governance. So it sounds strange, but I want to explain why I believe this. We'll be talking about plurality and diversity. I'll be claiming that plurality and diversity are the most central features of justice in Islamic law, which only arises because the locus of power is in community, and communities are multiple, and not in a state, where state is singular. It'll sound strange, but I want to bear this out as well. In my contrast, at the backdrop, I'd like us to think about the impersonal versus the human. I will be claiming that our modern condition, whether it's government, whether it's corporations, whether it's a debt-based, interest-based economy, I'll say our modern situation is very impersonal. We are subordinate to impersonal structures. And the contrast of this is the human, where there's no such thing as a concept which is leading, or a concept that is responsible, but people are responsible. And I want to show this very briefly what I mean by this. And at the heart of it, what's important also I'd like to end with, is the fact that, again, I don't think this is just an academic conversation. I think there are consequences of where we can go from here. And the reason why I'm saying that is we live in a moment where we all have to admit things are shifting. Things are crumbling. A welfare state is not capable of offering full welfare. We are in a situation where we have an economic system which is an artificial bubble. We know it has to pop, and we don't know when it pops where things will land. And so there's a sort of crumbling moment around us we have to recognize. Even the environmental crisis, I will claim, arises out of our theory of corporations and our theories of debt-based economies, which I can talk about very briefly at the end. And so we're in a moment where I think we have to be courageous enough to think about different ways of living. And I want to suggest some things we might learn from the Islamic tradition today that could be helpful for collaborative, social, community-led activism. And just as a small biographical footnote, that is what I see locus is in education. It's not in the law exactly. The law will always have mercy in it. But the locus of this is outside of the law. That's why Islamic law, to students of Islamic law, sometimes looks cold, because Muslims, young Muslims will come to it to learn the best way to be a Muslim, and they'll find very cold, hard rights between spouses, between this, between that. Because the point of the legal tradition is rights. We have to know what rights are so they can be enforced. The kindness is what comes on top of that. So I just want to say that justice is required for kindness, but kindness is greater. Then it says, عَدْلِ وَالْإِحْسَانِ وَإِيتَاءِ ذِي الْقُرْبَى, and he orders you to give to those who are near. And that's going to be this great stress on community, which I'm going to give in my talk, because it's community in which we have solidarity. And then it says, and that's what God orders: justice, kindness, giving to those who are near, relatives and the like. And then it says, and what God forbids is lewdness, you could say, for one. The next one is what is unknown, munkar, i.e. what is customarily deemed bad should be left. And then finally it says baghi, which is transgression, i.e. the opposite of justice. So I just want to give this as a framing for our entry for what we're going to be talking about today. One last micro introduction, although it's technically part one now, what I wanted to share, is that the discipline that we call Islamic law, its name in Arabic is fiqh. Fiqh does not mean law. Fiqh is an Arabic word that means deep understanding. Where is the locus of deep understanding? It's within a person. And so the legal tradition, at the get-go, it's a tradition in human reasoning. It is not a tradition of objective law. And what is the offshoot of this? The offshoot is that the Islamic legal tradition, and I'll come back to this point several times, is fundamentally pluralistic. No one speaks in the name of God authoritatively other than the Prophet Muhammad, God bless him and give him peace, who left the earth about 1400 years ago. So what took place after that, it was nothing but community. Community leaders, community scholars, and we developed a scholarly tradition which was pluralistic. People trying their best to arrive at a strong understanding, but there was never an authoritatively correct interpretation. And so what unites the Muslim community in its legal, political manifestations across history, it was this respect for an honest interpretation, a respect for an expertful, if you could say, dealing with primary sources and legal principles. It was not the objectivity of the answer. This is going to come back as we think about rule of law. I just wanted to say that. We cannot deal with Islamic law without pluralism. And this pluralism was very strange if you think about it in the early period. Because in the early period, like in the first, let's say, 200 years, if you want justice in Baghdad, you go to the chief judge of Baghdad. He will interpret and understand primary sources, he look at the person in front of him and he'll judge. Then he retires, and a new judge comes. And the same question gets asked, but the new judge doesn't see things the same way. He sees things a bit differently. So then the same question gets answered a bit differently. It was a cause of great intrigue and some frustration, how justice could have different shapes and forms depending on who's in office. And that's why over time, it took about 400 years, but over time, Muslims developed schools of law, which were, again, community-led, self-regulating groups of jurists who agreed on principles while maintaining internal debate. And that gave some form or semblance of uniformity, but real uniformity never existed. It was a community united in striving to identify the law, and law was with the community. So I just want to say, you can't think of Islamic law as a single objective. There are principles, boundaries, and spectra of interpretation. And this will feed into my insistence on plurality and diversity as I come to it. What you find in Islamic legal texts, their favorite mode of expression is the mas'ala. And the mas'ala just means the question. And so when you read a book of Islamic law, you'll just find lots of layered questions. If a man says to a woman, I marry you, and there are two witnesses and they're married. If the witnesses are deaf, then they might not be married. If the deaf people can understand sign language, then they are married. And so on. It's just layered questions. And the questions are so designed to allow the student in a classroom to pick apart the underlying principles. So if you ever have to derive a theory of how the law works, it takes a bit of effort because you have to penetrate these questions. It's not a tradition that deals in grand theories. Most of the books don't say marriage is about. Here are some examples. It's all example-led, the main books of Islamic law. We have the locus of justice, i.e. implementing Islamic law to resolve disputes, is a person known as the Qadi. The Qadi is the judge. A judge is appointed by government, and so government and power, and I'm going to come back to this in just a moment, but the Qadi implements the law of the juristic community. The content of his judgment has nothing to do with the government in ways that I like us to think about. And the Qadi's law is not binding on subsequent Qadis. So every Qadi is bound by the teachings of his juristic community. That's what stays ongoing and permanent. So I just wanted to leave this as some features that this tradition is one of juristic interpretation, juristic debate, and then self-regulating schools to determine what is the most appropriate statement of law for a time and place. Not bound necessarily by previous statements of law, but definitely drawing off of them, like every tradition does. Okay, now let's think about some of these points of comparison before I look at some topics of the law themselves. We speak much about the importance of a rule of law and a separation of power. While these ideals are shared in all traditions, and certainly these two traditions, how they land is quite different. I've already talked about, when we talk about a rule of law, in the Islamic tradition, the emphasis was more on the objectivity of the process more than the objectivity of the statement of law. Meaning, as long as we can show that a judge who is presiding over a case, or a mufti, so a mufti is the other public figure of law. The judge presides between cases and makes a definitive statement of rights. The mufti is more like we'd call like a solicitor, lawyer. The mufti gives advice, answers questions, but it's not part of a legal framework, meaning there's no bindingness in the statements of the mufti. And I did Google this once. Mufti Day in schools does come from mufti. It sounds quite bizarre, but you dress up like an Ottoman mufti, apparently is where Mufti Day came from. But you can look this up, and maybe I'm not right. I did read that once online. So, what we care about to make the fatwa of a mufti correct, or the judgment of a qadi correct, is the demonstrableness of the objectivity of the process. And that's what the self-regulating school does. In every time and place, jurists are a community separate from government by these schools of law. The Arabic word for them is madhab. In every time and place, they have leaders, they have authorities, they have lively internal debates, and they agree upon what is an appropriate statement of law in areas of internal debate. As long as the judge follows a standard of an objective process, this is what rule of law means in Islamic history, as opposed to the objectivity of a single legal statement. So I'm just saying process versus law. You can correct me whether this is a relevant difference or not when we come to the discussion. Separation of power is quite an interesting thing. Both traditions, I'm sure many others as well, insist on the importance of this to hold us back from the transgression of government and the transgression of people of power. But some would argue that the Islamic tradition has a deeper separation of power. And the reason for this, and again, I'm just proposing these as proposals, I'm very open to your comments and corrections at the end. It's because the legislative, the judiciary, the executive are still parts of government. They're parts of the systems of power. In Islamic history, and this is demonstrable across time and place, the locus of the law was never with the government. The government tried to co-opt law. There were particular times in history where government tried to make authoritative, ideological tenets of faith and to make them as law, but it never really held. On the contrary, what we found across Islamic history, and many books I can recommend to illustrate this, was that dynasties crumbled and changed quite frequently in a single place and across the Muslim world. The Muslim world became quite fractured about 200-300 years into the Islamic project. But Islamic civilization was not fractured. If you follow the history, this is like 8 centuries into Islam. Someone like Ibn Battuta, famous traveler, he could train as a judge in North Africa, and he could function as a judge in India. He was dealing with a single social, religious, and even legal environment across political domains. How was that possible? It was because the locus of power was in community. Dynasties, warring dynasties and rival factions, and in the second half of Islam, a lot of Turkic warriors, people from Central Asia, in various dynasties. They were, if they wanted to rule, they were subordinate to the power of the juristic community. Marshall Hodgson, Volume 2, is a good book to look at this. It's called The Venture of Islam, 3-volume history of Islam. In Volume 2, I think it is, he comes up with the phrase, he calls it the Amir A'yan system. Amir means commander. These are the warring factions and people who've taken control of a region, politically. Commander. A'yan means notables. The people of the community with whom the commanders had to negotiate power. And right at the lead of communal leaders were Muslim jurists. So Muslim jurists were champions of community. And Muslim jurists had a great deal of, they had nothing to do with governmental structures. They were fully regulated by the guild, which is the madhab. Yes, the power of government was required to give bindingness to the statements of the judge, because the judge might throw people in prison. The judge, I'll come to prison actually in just a moment. I'm going to talk about crime and punishment in a little bit. The judge will declare this person is this person's wife, not that person's wife. The judge might declare this is this person's son, not that person's son. So the judge is going to do some serious things. And the judge needs some authority to implement justice. So the political commanders appointed judges, but they had no say in the contents of judgment. Because for a judgment to be recognized, it was by the guild of community. And so this is demonstrable throughout Islamic history. It's a very important point. If you study the history of any pre-colonial Muslim society, from Delhi to Cairo, to Baghdad, to Syria, there is a shocking uniformity of structures. Public endowments, free hospitals, free schools, and always the authority of jurists to negotiate power with people of power. And this is one of the reasons in Halak's contention that an Islamic modern state is impossible. Because this idea of a community-led law created by experts, which is determining the space of operation of government. So what are the powers of government? It's determined by the community guilds. So government empowers judges, qadis. Qadis are Sharia judges. They can only judge in particular matters that Islamic law deals with. And the government is told, you can now come up with legislation on other matters within these boundaries. So if you want to do driving speed limits, it's fine, but a punishment that's acceptable is like this and not like that. If you punish too much, you have transgressed the limits. So this is the idea. The community jurists define the sphere of power, not the other way around. And again, this is really demonstrable as a feature across the Muslim world and across history. And what this means is there are natural constraints on the legislative power of government, natural constraints, because there's something higher than government if the government wants to be seen as legitimate. That's why all of these various factions that took over the Muslim world, they might have come conquering with whatever intent, but they very quickly molded into the patterns of Islamic civilization. They very quickly started giving authority to the Muslim jurists of the classical schools. And what that meant was there was a code above government, which is the code of the jurists. There's a limit to what can be legislated. In the modern nation state, we have, and this is a contention, I'm open to your corrections, because these are all parts of government, these branches of government are parts of government, there is no higher authority than the state. And so you can imagine a future where, like we've seen in the Second World War, where governments can support quite nasty things. We can imagine a future like that in countries that we really hope not to see that in. Because what is the objective authority above the state? There isn't one. That's the point of the modern nation state. It is God. That's one of the claims of Halak as well in his book. It has replaced God. Is that a safe locus for justice? That is something for us to think about. And so while all systems are trying to protect people from the transgression of government, I'd say there are particular features in Islamic law that are quite useful for us to think about. The modern state, and I'm going to be coming, hang on, in just a moment. So another thing I'd like us to think about, when we think about things that are really important to us, priorities, when we talk about justice in our modern lawmaking, we come about the importance of individual rights, the protection of the rights of individuals. Islamic law certainly shares that, but I think it puts emphasis on a feature we don't find in modern lawmaking, which is the rights of communities. And that's, I think, the one point that I'm going to keep coming back to, because community, as a locus for power and a locus for collective rights, actually becomes a shield between the individual and the government. There's a very interesting short article by the previous chief rabbi, Jonathan Sachs. He wrote a small collection of essays in the 80s. And he had a small chapter on family. And there was something he said the whole Old Testament is a story of family. And he sort of retold that story just in a few pages. But he said a statement I'm going to come back to again, which is this, that he said family is the greatest unit of resistance. When you have large families, large tribal solidarity, that's a protection against the transgression of government. Just let that play in your mind a bit. If you think about even the modern world, I'm not saying these are good places to live, but if you think about places where tribal society is quite strong, like the deserts of Jordan outside of the cities, and it's very tribal run, or you think about northern Pakistan, tribal areas the government has only limited control. I'm not saying they're great places to be, but it shows that the family as a unit of solidarity is extremely powerful. Part of what the modern nation state does, if you were to critique it, is it's because it is the sovereign and because it owns all of its citizens, its systems naturally break down other units of solidarity. And this is a theme I'm going to come back to at the end. So for example, if you need welfare, what is the unit of welfare? The law will never say it's your family. The law will say it's the government. So can you see what's happening? The way that we do lawmaking, we intend well. And I'm not saying one is right and one is wrong, but I just want us to think about other ways to live in the world. Solidarity units are not maintained by the law. You could say they are undermined by the law. And in so doing, we are actually breaking down units of resistance. We are increasingly becoming atomized individuals under government. And that only enhances the power of government over us. And so there's something interesting in Islamic law I'd like us to think about. It is community as a locus of power and community as a locus of communal rights that the law has to preserve. Let me talk about communal rights, and I'll come back to maybe the modern alternative, which I think is not as good. In Islamic law, one of the, again, paradigmatic features from early Islam all the way down to the end of the Ottoman period is the insistence that there is no one law for all people. Again, that's why the modern state Islamically is impossible in Allah's contention. There's never been a notion that one law is for all people. Sharia law, we always have this fear of Sharia creep, and if the Sharia people take over, they'll force this on us, they'll force that on us. But the truth is, when the Sharia was running its own government, it's in charge, its insistence was, this is not a law for everybody. This is a law for people who believe in Islam. People who do not believe in Islam, they should follow the laws of their faith communities. That's why I struggled greatly calling this system theocracy. But I asked ChatGPT last night, could I call it pluralistic theocracy? And I said, yeah, that's not a bad word. And then I said, give me examples of pluralistic theocracy. And it came up with, well, Islamic civilization, it came up with the Ottomans, it came up with something. I said, give me more examples. And every example it came up with was either an Islamic government or a modern nation state built on an old Ottoman paradigm. meaning it struggled finding, independent of the Islamic world, something that you might call this theory, a pluralistic theocracy. And what that means is, I'm not saying, tell me this word even exists or not, but the point is, it was a commitment legally by the jurists, i.e. that every community has its own law. I'm going to give you one example from the law of Abu Hanifa. It sounds so extreme. Abu Hanifa is one of the great Muslim jurists, and his school is the largest of the 4 Sunni schools. Look at this mas'ala, this question of law. It goes as follows. So in at least Muslim memory, and I'm not talking as a historian of the religion, but at least in Muslim memory, the Magians of Persia, they're known as the Magians, and as far as I'm aware, they're the same as the Zoroastrians. Part of their religious code was the validity and the permissibility of incest. You can marry your sister, you can marry your mom. So look at this question. In a Muslim government, Sharia run, an individual comes from the Magian community to the Muslim judge. And he says to the Muslim judge, can you please divorce me from my wife? And his wife is his sister. Now, incest is completely not allowed in Islamic sexual ethics. It's an invalid marriage, and it's a very abhorrent, disgusting form of sexual relationship. But the jurist said, at least certainly this is what some of the Muslim jurists said, the Muslim judge in the Muslim land has no jurisdiction to break this marriage, because this marriage was consecrated by a protected faith community. So this person has to go back to his own religious community and seek the nullification of his marriage. Next masala, the next question comes. What if both couples come to the Muslim judge, meaning the man and the woman, who happen to be brother and sister, and they've come to the Muslim judge saying, please break up our marriage, i.e. they've tried in their courts and they haven't succeeded. Here, the same Muslim jurist said, okay, the Muslim judge can break up the marriage, not because he's a judge of Islamic sacred law, but because he's acting as arbitrator on behalf of 2 parties who've both empowered him. And Islamic sacred law believes in arbitration, meaning if 2 disputing parties, if I have a dispute with my friend here, and I appoint one of you as arbitrator, we are bound by your judgment. This will have weight if it then goes to a judge thereafter. Point of my example is, even something as abhorrent as, from the Islamic point of view, perverse sexual practices, if they're part of a protected faith community, Sharia has no right to interfere. So the code of Sharia law is very interesting. And like I said, this is paradigmatic. This really was the mark of Islamic civilization. I think more than maybe any other legal tradition, is this ability to not see law as a centralized affair, but it's community-led, and the goal of Sharia then is to maintain the protection and the rights of communities to self-govern. Sharia is there to facilitate this, to ensure this. That's why it's very interesting. If you look at Islam, as the Muslims entered the Near East, you'll find many examples of minority Christian groups who actually preferred to be ruled by the Muslims than by Byzantine Christians, because they were not, Chalcedonian, they were Coptic, and so they were oppressed. And the Muslims didn't care whether you believe Jesus had one nature or 2 natures, as long as you got a community, self-govern. So it's a very interesting feature, but it arises because communities have rights as communities. And I think that's a feature that is something I'm curious to see what you think of in the discussion, but I think there's something there for us to think about, and I'll come back to this at the end. So if the jurists then have added another layer of protection, individual from government, and I'm calling this layer of protection community, then the jurists have very interesting ways to protect communities from the government. I'll give just a few mas'alas or a few case studies of this. Zakat. Zakat is obligatory alms in Islam. A person has to give it every year if they're above a threshold of wealth. It's an intra-Muslim tax. It's a circulation of wealth within the Muslim community. The assumption is the other communities will have their own ways to circulate wealth. This is the circulation within the Muslim community. Zakat was paid on gold, silver, trade goods, agricultural produce, and animal wealth, like livestock. Very early on, after the passing of the Prophet, God bless him and give him peace, I mean within like 15 years, Muslim jurists, the Muslim community reached at an agreement, which was that government have no right to account for your gold, silver or trade zakat, but they can account for and send collectors to your animal zakat and your agricultural zakat. Why the distinction? They call this public wealth. Your animals are out in public. Your field is out in public. A tax collector can come count your animals. The other forms of wealth are private. And they didn't want a situation where governments would use religious tax as an excuse to enter your home, or an excuse to count your money, or an excuse to violate your privacy. So Muslim jurists, even in this most sacred of religious duties, were giving more importance to protecting the individual from the government's overstretching arm than actually the correct payment of religious tax. Another example is generally the Islamic juristic aversion to taxation. There are some very fixed forms of tax. Muslim citizens have a circulating tax called zakat. Non-Muslim citizens have a particular tax called jizya. There's land taxes called kharaj. And there's particular, if there's a military conquest, there's some acknowledgement of booty, a little bit goes into a public treasury. There's fixed ways the money goes into a public treasury. Beyond that, Muslims jurists insisted that taxation is a criminal act if there's no demonstrable need. So even if there's a war effort, there has to be some demonstration that public funding is low to justify taxing the public. And over-taxation was seen as an oppression where people have the right of rebellion. And so this aversion to taxation was at the heart of why? Because my money is mine. The fact that you have a political military authority over this land gives you no right to my money. And so this is the idea of protecting rights. I'm not convinced we have the same commitment to that in the same way in our current arrangements. But again, that's what I'll be asking you for. As for the modern state, there's things to think about. Because the state has, in our modern predicament, politically, legally, I'm going to come to later economically, it has moving towards a direction of breaking up our solidarity networks, making us as individuals upheld by government. It allows the state particular powers, powers of surveillance, powers of controlling movement. The government can control which countries you can or can't go to. Is that a right a government should have? Or is the right to movement a fundamental right we have to preserve? So can you see, it's very hard to compare systems to say one is more just or less just. But you can think of what are the priorities. Which rights are more important? And it's here where I think across civilizational conversation is interesting. But the Islamic jurists would say right of wealth, right of movement, right of privacy is far more important. That's something for us to think about. Mandatory education, military service. A modern nation state can insist on all of this because the citizens belong to the sovereignty of the government or fit under it. Is that right? Yes, education is a great thing for people, but can this be abused? In Islamic civilization, which was not run by taxation, it was much more of a small government set up. It was about communal charity, communal endowments, whose locus is education, right? It's the other space outside of law, which really built up a pattern across the Muslim world. Education sits outside of government. Military is very interesting. In early Islam, there was no notion of standing armies. That did start, obviously, early on in Islamic civilization. So just think about this clash. We celebrate individual rights, but is that also a door to abuse of individual rights? An alternative is communal rights, and maybe a greater check on government than we actually have now. I'll leave that with you. Another important point of concern for us in modern law, obviously, is justice and equity. And what I want to do in this theme is I want to do a survey of 3 areas of law: crime and punishment, economy, and family. So I just want to look at 3 things. In a very brief survey, I want to share values and priorities in the Islamic juristic tradition as an opportunity for comparison. Crime and punishment is the hardest one. Because when we think about Islamic law, what is the first thing we think about? It's chopped hands, stoning to death, public lashing. And so crime and punishment is the most ugly part for us to be talking about, justice and injustice. And we can say modern states will protect us from that. And I'm saying, well, modern states have the ability to not protect you from a lot of things. But if I were to look at crime and punishment, let's just imagine a different way of looking at this. And my interest is in values, not to say that, again, one is better and the other is not better. If you look at the punishments that Muslim jurists allowed a government to have and insisted on some, there are the punishments known as hudud, which are the ones that make the news. The hudud punishments, hudud means the limits. They're so defined as these are limits that shouldn't be crossed. These are, if you like, God's punishments. And any government, but the reason why I find hudud fascinating, and I will talk about it, is the hudud are actually a limit on government as well. Because it's telling government there's something objectively above you called God. And the community of jurists represent God to the people, not the government. And they insist on these symbolic punishments as markers of the fact that this is still God's realm. God is over this government. Is this called theocracy or not? Again, you can share your thoughts in a moment. The way the hudud work, remember I said at the beginning, I said mercy outstrips wrath. The way that hudud work, when you study the law of Muslim jurists, the law is designed in a way to make the hudud almost impossible to implement. If you pardon the crude details, but I'm going to go into them just to give you a sense of this. Stoning to death of a married adulterer. This is from the Old Testament. It's not in the Quran, but it's in the Islamic tradition. It's attributed to the time of the Prophet. God rest him in peace. What Muslim jurists say about this, what are the standards to allow this punishment to happen? It's either a self-declaration from the person to the judge that I did this, to which the jurists tell the person, lie and don't tell them, because you shouldn't openly admit your sins. And the judge is told to tell this person, go away, I don't want to talk to you, at least 4 times. Or it's by witnesses who saw, if you can pardon the detail, who saw the actual act of intercourse, the actual act of penetration, 4 witnesses, and if any of them retracts the testimony, they all get lashed for false testimony, false accusation. What I'm trying to say, again, it's a very crude topic, it doesn't suit our modern sensibilities at all, as will the next topic I'm going to come to. What I'm trying to get at in this is, even this most crude and the most difficult of things for us to think about in modern sensibility, it's more of a marker that government has something above it, and it comes from this community of jurists. And the community of jurists are responsible for implementing it, and the community of jurists have designed a code that make it almost impossible to implement, because of the principle that God's wrath outstrips his mercy. And so what do these symbolic punishments represent? A, the dominion of God. There is something objective about government. And secondly, there's a whole theory of legal objectives that come out of this. If you study Islamic law, they call it maqasid al-sharia. It comes out of these punishments. They say Islamic law cares about preservation of life, which is about an eye for an eye, which is not one of the hudud, though. That's a punishment with individuals. You know, it's quite interesting. For the jurists, murder is not a crime against state, it's a crime against the family. And that family has the right to demand retaliation, or to settle on a financial payment, or to forgive. I talked about kindness is a virtue if justice is present. So actually life and murder actually is a crime against people, it's a crime against communities, how the jurists saw it. So they say Islamic law preserves life, it preserves intellect, which is the punishment for being drunk, which is for the Muslim community only. These are all for the Muslim community. These are not for non-Muslim communities. There's about the preservation of lineage and family, which is this example of the punishment for adultery. They talk about preservation of wealth, which is the punishment for theft. So the idea is there's a theory of ultimate important values to God, which every government is under. The jurists implement, and they implement with extreme mercy. Even judges, it's the only time judges are told to find loopholes. It's when implementing these hudud. The other kinds of punishment that the jurists allow for the government to have is what they call ta'zeer, meaning anything less than the hudud the government can decide. So the jurist will tell the government, you can legislate. Speeding violations, parking violations, this violation, that violation. You can create law. But within these boundaries, your punishments shouldn't include X and shouldn't include Y. What I find so interesting, and again I just find it interesting, and it doesn't suit at all our sensibilities. It sounds completely off the record, but just interesting. Classical Islamic law never had a punishment which was economic in nature. Governments had no right to fine people because of what I said earlier. It's my money. On what authority are you taking my money from me? You don't have that authority. Later in Islamic periods, they did introduce fining. The Ottomans had fining. And it had to be created through layered arguments. But the assumption and the origin was this is not an acceptable form of punishment. You're transgressing my right. Punishment's a very tricky thing to theorize because you have to uphold public order while not doing oppression. So that's where again the theory of rights becomes interesting. Imprisonment. Classical Islamic law generally has no notion of imprisonment as punishment. Because on what right are you curtailing my freedom of movement? The only time they really talk about imprisonment is really connected to debts. If I owe somebody money, then yes, the judge might lock me up and insist that I make an arrangement to pay somebody back. And it could even be my wife. It sounds quite odd as well. But within marriage, I will not be maintaining maintenance and the wife takes me to court. I might find myself in jail and I write letters to my dad and my family and my business companions just to give the lady money I can come out of jail. So debtors had imprisonment. They talked about that from the earliest period. People who have to go to court and they're afraid they might skip the court hearing, they might put them in a place for a while, but not punishment. And again, over time, these things developed. So it's very interesting. So what's left? If taking money is violating my right, imprisoning me is violating my right. So what's left? It's corporal punishment, the thing that we won't ever tolerate now. What's corporal punishment? Within limits. It can't be a punishment, the jurist laid limits on it. You can't lead to wounding of the skin. You can't lead to any long-term any physical damage. But it's just about inflicting a moment of pain and maybe humiliation. Like in the old English schools, maybe you're all here present, headmaster, hits me on the bottom or something. I feel bad, you laugh at me, and then we go to the next class. Sorry to make this such a trivial point, but it's not trivial. It's quite upsetting for us. But I just want to use this very controversial point to say even punishment is a space where justice is a very difficult thing to get right, because criminals have rights. And which of these rights is more important than others? Civilizations looked at this differently. But I'd like you to think about a right to wealth and a right to freedom of movement that government should never touch. And think about what punishments might be useful or possible. This is all examples of jurists restricting the power of government. So I'll leave this example here. I know it was maybe the most awkward one to talk about punishment. I'm going to move on. The economy. The economy is probably one of the most sacred spaces within Islamic law. Our Prophet, God bless him and give him peace, the first thing he established in his city of Medina, which is really the model of Islamic law, it's the prophetic project, if you like, in the city of Medina, which he established, God bless him and give him peace, over a period of 10 years. The first thing he established, the first institution was his mosque. And the second institution was the free market. There was an insistence that people should be free to trade without any taxation. People should be free to trade in a fair market. People should be free to trade without exploitation. And so this idea of a trade-friendly civilization, it's one of the paradigmatic hallmarks of Islamic civilization. A civilization of traders. Very, very much so. And so what the economy was, it's a space of free trade where exploitation is carefully monitored and government is carefully monitored. Two things. What is monitored in exploitation, I want to come back to this later, is the prohibition of obviously unfair market practices, but key to it is the prohibition of usury. Usury is exploitation by definition. It's me taking advantage of your need because I have capital. And I will enter a transaction with you where I get richer and you get poorer. I am using my wealth to take advantage of your need. And usury in the modern economy is incredibly disruptive. It's powered a lot of growth, but we're going to get hit in the face very, very soon. I'm going to come back to that later. So there's rules to control the market from exploitation, and then there are rules to protect people from government. What are those rules? It's things like the prohibition of price fixing. The Prophet Muhammad, God bless him and give him peace, was once asked, the prices are going really high, please fix the prices for us. And he said in a famous statement in the juristic tradition, he said, the price fixer is God. That's it. That's what he said. We talked about the invisible hand behind the economy. For us, that's the hand of God. And he said, and the Prophet said, I want to meet God, never having wronged anyone. Who am I to fix a price and hurt a trader? The only time Muslim jurists allowed for the fixing of prices was if there's real public harm in real public need, i.e. food. Otherwise, there's a protection. Governments don't belong here. Governments, and again, part of saving us from exploitation is about hoarding. So governments, just like they give power to qadis to run communal law, not governmental law, and then the jurists give governments a space to operate, governments also appointed people to manage the markets, and they were known as the people of Hisbah, ancient Muslim tradition. In fact, the first, Muhasib, at the time of the Caliphate of Umar was actually a woman. The first instated market inspector for the Caliph Umar was a woman. And these were people who just went around and banished people from the market if they were violating principles of justice. So government needs to empower fair markets, and they can't interfere with them. So another interesting thing in the economy is, I hinted at this earlier, our modern predicament is impersonal. I've said this a few times. We belong to government or state, but state is not a person. It's a group of actors that change, but we belong to the state. We belong to the nation. We are subordinate to an impersonal entity that we've created. Corporations can't exist within Islamic law. In corporations, there is limited liability, right? So that the members of a corporation can do all type of havoc on earth in modern law, and they're not responsible. It was IBM that did it. It wasn't me. In Islamic sacred law, this is not possible, because there always has to be a human being who bears responsible for all of these activities. In government, it's human beings. That's why it's not seemly to use phrases like Islamic State. It's become popular because state is used for this modern entity, and this modern entity is impersonal. And in Islamic governance, there is no impersonality. There's always people, because you need to make somebody responsible. In the modern corporation, we are subservient to a thing we invented. We call it profit. As long as a corporation is profit-seeking, it is acting correctly. Otherwise, not. So I just want us to think about how much we are subordinate to the impersonal, increasingly so. And that's part of the modern condition, really. Last thing I'll say within the economy, the Muslim jurists never countenance a company structure for profiting off of natural resources. And that's based on a theory of ownership. What's a theory of ownership? What is free in nature, anyone can own. So rain falls from the sky, it's free. I collect it in a bucket, it's mine. I can take it, I can sell it. If you take from my bucket, you're stealing from me. So everyone has the right to own anything in nature, but you can't do it in a company structure. Reason being, if I form a partnership with my friend over here to collect water from the river and sell it in town, the problem they say is, once I've taken the water from the river, I'm the owner of the bucket. That ownership does not transfer to my partner, and therefore there is no possibility of a company structure to profit off of private resources, or off of public resources rather. And this notion of public resource profiteering, it's one of the quite complicated, difficult, you could say, I won't say disastrous, but that's too strong of a word. But it's something we really have to think about as we go towards future for humanity, and law should have something to say about this. Last one in my survey of just a few areas of the law is what I call family law. Family law is another place where rights clash and legal systems betray their priorities. What is a priority here? It's very evident that in our modern legal structures, the individual is primary, more than the family unit, more than the children. So for example, there is no notion that a wife has anything she can demand from her husband, any particular right. She has a right not to have her freedom violated, this is true, but not a right to maintenance, as the Muslim jurist would insist, or other such rights. It's a partnership of equals. Correct me if I'm wrong, that's how I see it. A partnership of equals. We've come together to enjoy this company, but the law won't give a protection to the unit over the individual. Rather, it's the individual that counts. In Islamic law, there is, you could say, a greater insistence on the communal, i.e. family, and that's my theme throughout. Family is an important unit of society, so children have rights that are maybe even more important than the rights of parents. And the unit has a right more important than the freedom of individuals. So for example, and there's a very good book on this, it's called Marriage and Divorce in Islamic Law. Joseph Rappaport, he's a lecturer in Queen Mary. He surveyed actual divorce cases in medieval Egypt in about 9th Islamic century or so. And to show that what the Muslim jurist said really happened, is that within marriage is a coming together of a man and a woman. Islamic law is quite gendered, so there's particular notions of responsibilities based on gender. And a man is duty bound to provide for the family, even if the woman is rich, even if the man is poor. Because that's what marriage is. That's what he's bringing to the marriage. And if the woman's not getting her maintenance, she can take him to court, get him put in jail, it's very strange. Get the judge to give her the ability to borrow in the man's name. And he has a whole book on actual case studies about this. What is this illustrating? The unit has rights. Again, that's the theme throughout my presentation. The unit has rights. When the jurists speak about maintenance is fundamentally family-centered. So if I'm struggling financially, there is no notion that government provides for me. Rather, the law will define my maintenance from my family structures, if they can afford it. And it goes through family relations based on inheritance. It goes to my father, it goes to my brothers, it will go to my cousins, it will go to somewhere. And if they can't maintain me, then yes, I'll get maintenance from the public treasury. And like I've said, this confirms, the law is confirming communal solidarity in maintenance. And I argue that modern law, it has an interest to take away these notions of solidarity. Another thing that's interesting is this mind-boggling, almost, insistence on lineage. Then every child must be attributed to a lineage. No child should be lineage-less because of what I've said, because maintenance and responsibility is tied to human beings. Children don't belong to state, they belong to families. And so if a child is born out of wedlock, the lineage is to the mum's family, and then they will be responsible in front of the law for maintenance, for education and related things. If there was a marriage, the child belongs to the lineage of the dad, and the dad is responsible until the child is an adult for maintenance, for education, and if the child has any crimes financially, the father is responsible. So it's really interesting. It's a law that's more concerned with the unit than simply the freedom of the individuals. Not to say right and wrong, but these are priorities for us to think about. I argue it builds community and it strengthens family. And we can argue whether that's something we would prefer or not. Just a few more points before I wrap up. I've just got 2 points. One point is, where is the locus of justice? And one point is, what does all this mean today? And then I'm done. Locus of justice. We all know that there is no possibility of absolute justice on earth. It's not possible. Because evidence can be tampered, because witnesses can lie, because judges can misjudge. We all know there is no absolute justice on earth. But legal systems are there to give demonstrable fairness to the best of our abilities. And all the things we discussed previously will feed into demonstrable fairness. It's interesting to ask, how would a religious community think about this question, the locus of justice? So in the Islamic tradition, like in many, absolute justice is with God, and it happens on a day of judgment. And so the story of humanity cannot conceivably end until there is justice. And that's again underscoring the centrality of justice in the story of what it means to be a human being. There must be justice. And this is taken as a point of comfort for people who experience great injustice that the law does not offer them. But it factors fascinatingly into features of lawmaking. I'm going to give just a simple example of this. And the example is that of the Arabic word is hila, and the English term is a legal stratagem. We all know that legal systems are open to abuse. Anyone who knows the law well knows how to dodge the law, knows how to find loopholes within the law. But what is so interesting is when jurists actually theorize the morality of dodging the law. I'll give you an example of this. Some of our jurists, again, example is from the Hanif school, the largest legal school, they said that if a person feels they're being wronged, here's an example. A woman after divorce is guaranteed up to 3-4 months of maintenance payments from the husband. So she claimed, and also, maintenance during marriage, monthly maintenance. So she was divorced, and she tells the judge, my husband hasn't been maintaining me, and he owes me money. She tells the jurist, she hasn't got proof for this, to prove it in a court. The jurist, the mufti, who's not binding, mufti is told, and I'm quoting here the Mabsut of Imam al-Sarakhsi, a great Islamic authority, the mufti will tell the woman, okay, why don't you deceive the judge and say that your waiting period hasn't ended, it's tied to 3 menstrual periods. So instead of making it 3 months, maybe extend it to make it 6 months or 7 months, because only you know when your menstrual period happens. Prolong it enough that you get the money that he owes you. What is this? It's a religious scholar advising his client how to deceive the judge. Why so? Because of the understanding that the real justice is with God, and this person knows that they've been wronged, and the judge is not going to judge in their favor. Again, this might not sit well, but why I want to just raise this is this interesting fact that even the judge is not the final authority. God is the final authority, and the Muslim advisors, who are the muftis, they have to advise their clients based on what their clients believe is real. Meaning, if you believe you've been wronged, I have to find a way to help you get your right. I have to advise you how to be in court to get your right. And that's something Muslim jurists, at least some of them, have theorized. It's a point of debate, how legal stratagems work. But I just want to say it's also an interesting feature where the judge isn't everything. It's understood there's limits in justice. And it's understood that as an expert in the law, I have to help the person in front of me. Many people feel deeply wronged. How can I help them find justice? Because the real court is a court that we're going to meet with God. And I just wanted to leave that as something to think about. And the last thing, I'm sorry if I'm quite a bit over time, I do apologize. The last point is, what does all this mean today? I said at the beginning, when we learn from other cultures and civilizations, it allows us to reimagine some of our premises of what is important. I've shared some details, some of which are probably shocking, some of which might have been uncomfortable, but it is to show that when we think about justice and rights, it's not an easy equation. And there are particular priorities we'll have to choose. And there might be some priorities we might feel we have to champion. I believe, as a people dedicated to the law, we have to be dedicated first and foremost to human beings. The right human beings have to live with dignity. I've done a lot of anti-government talk today, and it's not that we have to be anti-government, but we have to think about where should justice sit, and what is our role as people who speak in the name of the law. I will argue we have to be activists for justice. Social justice activism is normally associated with people of a particular bent in political thinking and social thinking, but I'm saying this just in general. We have to feel responsible for the state of the world. We have to feel that what we learn in universities has a consequence. And we have to feel that we have the power to effect change. And we have to realize that change doesn't only come from the structures we associate with law. I do believe there's something we should take away. The locus of power is always in the people. However we might theorize, power is always with the people. And if we feel any system has gone too far and people are too exposed, I feel we have a responsibility to move that better. And I think that's at the heart of what it means to be dedicated to law and legal thinking. So a few things to think about. Community solidarity has been a theme throughout what I've shared. It's something which I feel, whether we like it or not, the welfare state is crumbling. There's no doubt about it. There's a crisis of poverty in Britain. There's no doubt about it. People just don't want to talk about it. Many, many stats can be shared about how many children live in poverty. There's an article last summer that is stuck in my mind from Gordon Brown. He said people who come after us will criticize all of us of our time, how we tolerated such poverty, and we just crossed the road and left it. Houses upon houses of children who don't have food on their tables, have bedrooms without beds. This is actually what he said in his article. The welfare state isn't keeping up, it's crumbling. Who should keep up? From the Islamic tradition, I'd say it has always been the job of community to step up and look after community. This is happening in modern Britain already. If I go to Tesco, I always get this Don's food bank outside. People are stepping up and they're forming community solidarity networks. This is another way of living. This has a consequence on politics. It has a consequence on political power. It's a shift in the locus of power. I'd like you all to think about what we want from this movement. I left the classroom 3 years ago to join this project, National Zakat Foundation. At the heart of it, what I wanted to contribute to building, because I felt the Islamic tradition had institutions the world would benefit from, it was a community-based, look how strange this sounds, community-based taxation system. I don't use this phrase in public, but you're obviously law people. Meaning, a community can feel duty-bound to pool wealth and to spend fairly based on a standard that is above the community. In this case, zakat, the obligatory alms. And we're doing some really interesting things about community-based cash distribution. We are the largest cash distributors in the UK, to the best of our knowledge. We redistribute within London alone about more than £4 million of cash, just redistributed in London alone. And this is, although it's circulating within the Muslim community, these are people who otherwise would have been a strain on public expenditure, and local governments are crumbling. We're working with technology and community-led support networks. I think we're creating a model that I think modern society needs to observe, collaborate with, and be a part of. And we're part of larger conversations with MPs, with local governments, with faith projects like the British Red Cross and Trussell Trust. I think the project which I'm talking about is an instance of what I'd like us all to think about. That other traditions and civilizations have institutions that are deeply meaningful. They have locuses or loci of power, which I think going forwards modern Britain needs. And so I'm calling you all to invest in community thinking. And I think that's going to be a necessary shift in power that's happening anyway. But you can theorize it as people of law. Another thing I'd like us to think about is the pervasiveness of usury and the disaster of the modern economy. Because the modern economy, what is its basic principle? In any one moment, there is more debt than money. That's it. There is never enough money. If you just press pause on the economy, add up all the money in the economy, add up all the debt, that will always be greater. Because the premise of the modern economy is most money is not printed. Most money is created in a loan through a bank. So they create the digital money, and they can offset it with a debt that's greater than it. That's how they balance their books. So always there's more debt. That is a burden on the planet cannot bear. Because we, under the yoke of debt, we are pushed to become a different type of human being. We are pushed to have mothers and fathers working in full-time jobs just to secure shelter. Did it have to be that way? Not really. We are pushed to cut down trees because a tree in the forest can't pay back our debts. But a chopped down tree, I can bring it to market, I can pay off today's debt, but tomorrow's debt will be born again. If you're an environmental activist, you have to be an economic activist. Because the logic of usury is to destroy the planet. The logic of usury is sometimes to go to war, because that's another way to offset debts, national debts, pass them on to another country. If you're a peace activist, you have to be an economic activist. These are particular features in Islamic tradition, which are actually, this particular point is an old feature in almost every religious tradition. But the Muslims have sort of held on to it. In modern Islamic conversations in Britain, there's an evolving conversation of how to tackle usury. There was classical Islamic banking, which is creating a space for Muslims to house own, really. But I think we're in a space of really creative conversations now. Creative, communal, social structures to share funds, to own houses, to earn profit, but not through debt. A project I'll name to you, which I'm aware of, I know the founders, is called FIDA, PFIDA. You can Google it, community-based house ownership. I think it's a creative time to find alternative ways to live and share funds. I don't mean necessarily communism. You can earn a profit, but without debt and without usury. I think we have to part of economic activism. When it comes to family, I won't say much. I think these are quite opposing values. You know, a family-centric, child-centric worldview and what I call the individualistic one. You might not have to feel, maybe we might not feel that we can have to translate all of this. So I'll just leave that there. I've got nothing, no activism I'm calling you to on this front. Although for Muslims in the room, I would say one thing. Islamic family law only works if there's a way to receive justice. Otherwise, the weak in the family, women and children, don't get their rights. And that's why if there's any duty I think Muslims have in the UK, it's to build Sharia arbitration. That's a very scary thing on the news. But all it is, it's community-based, authoritative structures where people can come and people can have some of their rights looked to. So I think that's a form of activism Muslims do need to invest in. It's a very precarious space, but it needs to happen. The last thing I'll say is the plurality. I said plurality is one of the paradigmatic features of Islamic law. Intra-Muslim plurality and community plurality, religious plurality for people to live as they believe they ought to live. I don't think any civilization can have a better record, I think, than this community in this principle. It's something I think we can draw from as we chart a new future, which I think needs to be community-based. It needs to give more power to community structure. I think we all have to commit, Muslim, non-Muslim, believer, non-believer. We have to commit to our communities of interpretation or communities with codes of justice, and we have to work together. I think there's something here, if we don't do this, I don't think we're going to succeed in, it sounds quite a big thing to say, but to save Britain. Sounds strange, isn't it? I think there's a lot of challenges that's happening right now. As the challenges grow economically and politically, it's very easy to blame marginalized communities. The opposite is building a community infrastructure of collaboration and plurality that's so strong, it catches what is currently being dropped. I'll leave you here with these thoughts. Like I said, I'm not an expert in Western law. I wanted to present some features of Islamic law to facilitate reflection and comparison. I've talked quite a bit actually, unfortunately. It says what? 1 hour and 16. I wanted it to be 55 minutes. Thank you all very much for your patience. I'm happy to stay for questions as long as this gentleman allows. Thank you very much indeed. Why did you call me then? Imam Khan is he's the Dharma of this.
Yeah, well actually you developed the point of questions you speak about sort of coexistence of Muslims with Christians and Jews. I wanted to know how far that extended within their bubbles, how they things like within their own deliberation. And you asked that was sort of lead me to the next question, which is how far that extends to existing responsibility to that is
about what kind of separation within communities. We talk about communities living in a world where people are encouraged not to subscribe to a single moral and communal code, but they're encouraged to follow those of their own. What are you actually doing? You are not telling people to live in bond-of communities, although many people like that, and they're welcome to live like that, but you are encouraging necessarily for there to be the rise of institutions. Because if people are encouraged to resolve marital disputes within community, to resolve maybe financial disputes within community, then what are you encouraging? People should increasingly belong to communal infrastructure, build institutions across all of your codes, based on all of your religious standards. That's what this will end up as. So you can live side by side, and you can still say, well, I'm part of Cambridge Mosque, so that's what I'm going to go for my X, Y, Z. And somebody else might be part of another mosque or another church, and it's okay. We belong to community. Where there are possible gaps in this theory, many things we might struggle to understand, because I don't have a good theory of it, is someone who sits outside of a community. I think the Islamic legal tradition, in my reading of the classical texts, I've not seen a strong theory for this. It's almost like living outside of community is an aberration. You almost have to choose who you belong to, almost, and then you'll be governed in that way, and you'll be supported by the government. But it's just interesting, that's like a front line of this clash, if you like, of the communal vision and the individual one. What if I don't want to belong to anybody? And the idea is, well, who's going to look after you? What's your solidarity? What's your marital, how are you going to live? It's almost like you can't live alone. You live in a code, and the code belongs to a community. But that's just the front line for us to think about. But it's not about ghettoization in space, although historically many people have liked that. To this day, in Jerusalem, there's the Arab quarter, the Jewish quarter, but it doesn't mean that they don't actually can't also live side by side. It's just quarters facilitate, meat butchers and places of prayer. So it's a natural thing, but it's not a necessary thing. It doesn't always happen. The other thing you said was, it's something I've puzzled over a lot and I don't have an answer to. Is there's no doubt, again, I'm not speaking as a jurist today, I'm just trying to interpret the jurists of the past. Muslim jurists saw people belonging to faith communities. And it didn't matter which faith community it was, that community would be sacrosanct. They would have to be protected, and that's part of what the Sharia jurists would make the government do. You've got to protect them to follow their code. What about if it's a non-religious community? And it sounds so strange, I don't know how to answer this question definitively. There's two possible answers. One is yes and one is no. Let's think of a really extreme case, which I've puzzled over. Imagine because I said Muslim governments enforce thin areas of public law. So no one can kill, no one can steal, and you can't do usury. It doesn't matter which community you belong to. There's a thin area of public law, and the rest is communal law. So things like, for example, gay marriage, that's a controversial one. If you imagine that gay marriage is not allowed in any religious community whatsoever, let's just imagine that. And I know obviously the church has conversations and everything, but if you imagine there's no religious community ever that allows gay marriage, but there's a community of self-governing a community, right? So imagine, I don't know, the breakdown of government in England transformed, and this, the people of jurists, like in this room, you studied in Cambridge, you self-regulate. Cambridge, your community follows you guys, and they don't have to, but they choose to. And you've made your own sexual ethics, you made your own economic ethics. Is this something that a classical Muslim jurist would say it's fine, we have to protect it, because it's a self-regulating community? Is that the point? When they preserve the right of every community to self-govern and legislate, is it because it's a self-regulating community so they can take care of their disputes? If so, then the answer will be that any atheistic, secular community, as long as they have a mechanism to resolve disputes, they can follow what they believe to be right. That's one answer, a medieval jurist might say. And the other answer a medieval jurist might say is no, we are a pluralistic theocracy, if that word exists. We are here to preserve the rights of religious communities. We weren't here to encourage people to break away to an infinity of possibilities. Do you see what I mean? Because religious communities are bounded in some way. There's some shared values across all old codes, even if they might differ on details. So the jurists might say, no, hang on, we preserve ancient communities, ancient wisdom, and they'll change in small ways. And we believe in that. We believe in the right to believe in the sacred, and we are here to preserve the sacred. We're not going to encourage the societies to, again, self-regulate to any possible infinity. So if you went back in time, the jurists might say A and might say B, and I'll leave it with you. That's how the argument would have to be made. So I'll leave it at that.
I have a couple of questions. First, it should be a quick one. The 2013, the guy who wrote the book in 2013, what was his name?
Yeah, so his name is Wael Halaq, W-A-E-L H-A-L-L-A-Q. He's been a Palestinian Christian, a leading researcher in Islamic law, but he completely sidestepped his expertise into a new area in about 2010-ish. He wrote his last book on Islamic law called Sharia, and then he entered this really interesting new project, which, if you're interested in any of the themes I said, he's the major author now to read. The first book was The Impossible State, and now it's laying out an analysis, a moral analysis of the modern state. And Islam has an alternative way to think about being a human being, is what I've said. His next book was Restating Orientalism, where it's a critique of Edward Said's book on Orientalism. And what he wants to say is, all of modern knowledge is complicit in the all-pervasive project of the modern state. There's no independent knowledge. That's the theory of that book. And right at the end, he says, how do you introduce new knowledge into modern knowledge? He actually says, look at departments like Oriental Studies, which is what I said today. Other ways that civilizations have solved their problems. His next book, which I've not read unfortunately, he calls it Restating Modernity. And he's looking at a contemporary Moroccan philosopher, and there he really has taken it to the core of human morality. Because the whole arc, from someone who's been one of the leading academic authorities in Islamic law, but that's his name.
Thank you. My second question was, you talked a lot about the rights of the community, and you did touch on how an individual might be able to, if for instance their family is abusive, they might be able to appeal to the community, and that makes sense. How do we protect individuals from malicious communities? And I think a helpful example that came to mind was slavery. Because obviously, as you're saying, in the Hadith, Muhammad is very clear about his, the invisible hand is God, etc. But obviously we would feel very uncomfortable with slavery. And I know obviously Muslim scholars have also felt uncomfortable with that. How do we protect individuals from a community that is protected to be a community with its own faith laws?
I answered everything you said until the last question. Can you restate that?
So how do we protect the individual from the community, which is said, the way that we are interpreting Allah's laws means that we can have slaves and treat them badly?
Yeah. So, this is a very, very fair question. I'll say a little bit about slavery in Islamic law, but at the end of my answer, I will also have to put my hand up as well, in the sense that it goes back to a point that I've made as far as I can see. Absolute justice needs to take place outside of the human realm, but we have to have enough checks to protect people. And so, like I said, there was a thin code of public law that jurists maintained, and this would all be part of it. But it is interesting if we're preserving, I don't know the answer to this question, by the way, if preserving a Christian understanding of slavery, for example, if there was such a thing as an authoritative church doctrine of slavery, how a jurist would deal with this is not clear to me, and I'll explain why.
There is a Christian.
Yeah, so it depends on the details, like how detailed it gets into rights and responsibilities.
So there is definitely that. So that's
fascinating. Yeah.
From the Christian perspective, that wouldn't be a problem. And for instance, obviously the transatlantic slave trade completely disregarded the Christian doctrine of slavery. That's obvious, anyone could look at it. But because you were talking a lot about how it's about process, it's not about absolute rights, really interesting perspective. But what if someone says, well, the way that we process our understanding of Allah's laws
On Islamic jurists and slavery, first of all, I had a student when I was at Cambridge Muslim College write a dissertation on the slavery within Islamic law. And what was interesting was that we worked on that project. So definitely the jurists, because they're dealing with rights and not with the kindness there, which they dabble in only. But on the level of rights, the jurists did not abolish slavery, but they restricted the rights of it. And I wouldn't say in the summary that the process is more important than the rights. I think the rights are part of the process, right? And I'm showing you which rights are more important. So there was such a thing as a human being who was owned, this is true. But what was so fascinating was how it was regulated, the institution. So pathways into slavery were highly regulated. And then obviously lots of ways for people to come out of slavery. Jonathan Brown has written one of the, I think, important works on slavery in Islam, which came out about 6-7 years ago. He showed that in the Islamic world, slavery was rarely cross-generational, because there's features in the law that just facilitates exit out of the institution. But what was so interesting thing was that a slave was, although there's an economic restriction, the slave was a fully human part of society. So a slave had rights to go to court if the slave is being wronged. A slave could lead communal prayers, could lead Friday prayers. A slave could take people to court for any one of bodily or other crime. There's quite a few features in the law where the slave wasn't subhuman in any of the basic rights, and they were quite enshrined, but there was such a thing as still property. Yes, this is the thing. That was definitely there as well. So all I'll say is it's a very different kind of highly regulated slavery within a rights framework. And all I'll say finally, because your question was more about today. So let's say today, if you imagine the structures like I'm saying, then who is the arbiter of law? It is the community of jurists. And if we say that this is an uncomfortable conclusion, it's very hard to, I guess what I'm trying to say is it's similar if we use modern law, and if we say that all the legislative says we should kill all of the X type of people, what's the check on that? There's no theoretical check on that. So that's where I think limits of debate have to be considered. The only difference here is that the debate is taking place outside of power, and so government has a duty to maintain public order. And so this will be a duty of government to restrict such debates. Another book that might be of interest, Colin Imber, he has a book on, he calls it Abu Saud, I can't remember the subtitle. Abu Saud is one of the most famous Shaykh al-Islam of the Ottoman Empire. He theorized how to bring this juristics law closer to the seat of empire, to allow the Sultan a greater exercise over managing debate and preventing such things. There's a part of, again, this is what we call the job of government, where there's a spectrum of debate, the government has to choose something on public order, but it can't go out of the spectrum of debate. That's where the balance is. I can't answer much better than that. So.
That's really helpful, thank you. That's explained a lot.
Okay, thank you very much.
You mentioned that there's a very thin layer of public law which the government condemns. But even that, you said the jurors, given the scope or the boundaries within which they can set that law. Mechanistically, how would that work? Would they choose certain jurors? If so, is that like an option to provide? How would that work?
Yeah, it's hard to picture 100%, but it really does seem like a meritocracy, meaning all that we can see from history is that there are people who are well known for contributing very important books, and there are doctrines which are seen as school doctrines, which are conveyed through authoritative texts. And there's a fatwa tradition, which is again individual jurists who come up with creative answers. So any jurist can propose any creative answer. But unless the school tradition accepts it as a school answer, it won't make its way to a court. It won't make its way to anything authoritative, but it exists in the academic debate. So all I'll say is it really does appear to have been self-regulating. As long as you can argue within the confines of a legal school, then your position has weight, especially if you are recognized amongst your peers as having weight. That's how knowledge works in the academy as well. In the academy, we all know who are the well-known experts in any field. They publish a lot. they define the discourse within a field. Fields develop in the academy, not primarily through bias, but primarily through a community which gravitates towards strong arguments. And so it's an academic space. And I think it's similar to what we find here.
Any other questions? No? I have a very interesting question. So today we probably understand well with lots of algorithms that govern so many different places, especially with, I think, probably the conversations very much started to come up now that with AI, maybe so in AI, how does it define the law and these kind of things. And my interest is basically how, because there are lots of questions within the science law, someone not being liable for what they create is useful. Someone not being liable for what they create is useful. So I say, for example, I create a knife, I'm not liable for who one person uses the knife for.
Yeah, correct.
How do we do the same with the social media algorithm? Because
Someone-
someone needs to be liable for social media and sort of how it works society.
Okay, that's very interesting. We have to come up with a crime to analyze, right? Let's say the crime is which happens and where a child commits suicide, and that's and although there's no murder as such because it's self-inflicted, there's a sense of someone's culpable. These children who spend time online and suddenly they start hating themselves, and it's a very sad thing, and it happens. So, okay, now I've come up with the question. Now we have to come up with the answer. It's a very tricky one, and I think, it's a very good question because it shows the similarity between what we call Islamic law and Western law. These are legal traditions within premises who have to come up with difficult answers. Any answer that is well reasoned within the premises of the tradition is a possible answer. I don't want us ever to think Islamic law is somewhere and Western law is somewhere. That's a very common thing in Muslim social media, that we want Islamic rule, not Western rule. And they don't realize that much of lawmaking is not dealing with things in sacred texts, it's dealing with things that lawmakers have to come up with. Traffic law and social media law. Muslim jurists, non-Muslim jurists are working with very similar premises, in very similar activities. There's no reason why they might not come up with very similar questions. So it's important is to realize that similarity and not complete separation. And after that, I think it's hard to say the creator of the system is responsible for this. We can say they were irresponsible and maybe we can block it if we consider harm. That's another space where government might have a say in its sphere of managing public safety. And we can say people who create content that encourages self-harm, to the degree that we find them culpable, we can come up with an appropriate punishment. This answer, I'm sure, is identical to what a Western jurist might come up with. I don't think it's that much different. There's a masala in Islamic law that's relevant to me here. Abu Hanifa says, may Allah be pleased with him, he says, if you sell grapes to a person you know is going to make wine with them, you are not responsible for that person's act. You're responsible for your act, and your act is selling grapes, and there's nothing wrong in selling grapes. So you are not culpable for the acts of another person, within limits. What if you sell, this is the alternative, so what if you sell guns to a rebel at a time of sedition, if you can define these terms? They say then it's not allowed, and you are culpable. Because the crime of public disorder will come with the item that you're selling, whereas in grapes, there's another step to make it into wine. So there's a theory that Muslim jurists have of culpability. As long as I can show somebody else chose to do something bad, then I'm not responsible. And if I'm somehow facilitating the very thing which is bad without the other person's act, and the other person's act is likely, then I am responsible. Again, Western law will have probably similar premises, and it's within this we'd have to answer your question.
Any other questions from your
Yeah, that's all really interesting. Thank you very much for the result. I'm interested in view of apostasy in Islam, and the impression that I get is that the Quran doesn't specify that much about the treatment of apostasy, but in the early Middle Ages,
on the like they definitely want to, if somebody who's legally Muslim wants to choose a different religion, then like they get killed, because the only way, apparently the form of leniency is to basically say that they don't actually apostatize. But if let's say I'm born a Muslim, or somehow legally considered a Muslim, and then I decide I actually don't want to be Muslim anymore, I want to be a Christian, I can, like, I'm not going to just take my lawyer's advice and, like, lie to the court and say, oh no, I actually am Muslim, right? So it seems very, seems like this is not really helping with the idea of, I guess, like, the separate communities or whatever very much, because basically the ones in power gets to make the rules and define who's within our Muslim community, make it impossible for everyone to leave that community. So, we've got another question, but I'll come back to that. But basically, yeah, what do you think? Why is it that basically all jurists said that someone becomes Christian, they should be killed? And how do we kind of think through that in the modern day?
Yeah. It's a very tricky question, because remember I said there are fault lines when you come to the individual versus the communal. And I said, what's the fault line? What if I want to exist out of community? But then it wasn't conceivable.
Well,
But you're talking about shifting communities, right? So
maybe the person might not. I mean, you could say it's shifting communities. That might not be how I see it. I might see it as sort of taking a stand for the truth as it's been revealed to me.
correct.
So I might be thinking more in terms of truth rather than.
Yeah, that's fine.
Yeah.
Very, very good. But after you've committed to truth, you'll belong to a community. I mean, so this idea of community individual is attention. This is right at the head of the tension. So the way it works is, you're completely correct in everything that you've depicted. It's not in the Quran, but it's found in early practice attributed to the Prophet, or statements from the Prophet who given this. And it's an understanding of the early community, and early jurists unanimously in some way gave deference to this idea. First of all, the debate, and I had a student also write a dissertation on this, slavery, and only once a year we did dissertations. One on slavery and one on apostasy. The apostasy, the only interesting debate in apostasy, I was careful in how I delineated these hudud, or these God-instated punishments. There's a debate, is the punishment of apostasy God-instated? Meaning, is it God's right, or is it a communal right? So the scholars of the Hanafi school of law, they treated this as more of a communal right than a God right, and they called it hiraba, meaning it's a sort of, what can you say? You know, in the modern law we have this thing of treason. It's an Islamic version of treason, stepping out of community. We have that in the modern state as well. If I somehow declare myself out of state, then I'm suddenly out of law, and my blood is not the same as somebody who is in law. So it's the Islamic version of treason, which only applies within the Muslim community, not outside, so it's not imposed on other communities. Now, in this law of treason, the Hanafi scholars saw it as that, but they saw it as opposition, and what they meant by that was, they only applied this to the kind of people who could be seen as a threat to public order. So for them, women wouldn't be killed. For example, the women are not military actors. It was tied to a notion of your potential threat to community by choosing to step out of. My goal is not to defend. I'm doing my best just to give a reason within the tradition. I'm not saying right or wrong here, but just to give a context to everybody else. That when you look at it like that, then in principle then, a juristic community has a say in assessing whether this is likely to be a case of treason or not. And if you look at again in the old model, if there's another principle, which it's fair what you've said, there's another principle jurists are concerned with, it is still preserving this particular protection, if you like, of the Muslim community, only in things like this, where if I guess the fear of the jurist is, in the argument, We don't want to facilitate a culture where it's publicly acceptable for people to leave the community. It can be privately acceptable, which you're completely correct, which is choosing to believe something, having personal practice. But you're completely correct. If somebody declares publicly and consistently and and so on, then that's how they viewed it. And the only thing I can say is the jurists who didn't view it as a had punishment, they would have scope to analyse how they want to apply it here. That's the best that I'm aware of.
So, could you explain I don't understand what you mean by private and public, because my world, everyone lives their life in the sight of God.
In the sight of God.
So there isn't like a private, I don't have a private life which God controls and a public life which the state or the Islamic jurist controls. Because I just have my, like, I'm not going to believe something in my heart and say something different with my mouth. Does this mean that basically I have to either do that or be
If people are stating this, then yes, it is behind the
So
law.
I don't have to threaten the community in any way. I just have to, when you put me on the spot, I just have to give, like, state my honest opinion when you're kind of like adjuring me to give my opinion, and that's considered a threat to the community. Is that what you're saying?
That's what it appears to be, if I was to argue about it. It's part of an extension of another feature, which is that vice, although there's no punishment for this though, vice is not meant to be in Islamic morality shared publicly, meaning that if somebody slept with somebody out of marriage, the appropriate thing to say, if they were asked, have you slept with someone outside of marriage, the appropriate thing is to say no.
But if you ask me, do you believe the Quran is true, for instance, if let's say I don't,
Yeah.
well, I would just be lying if I said I do.
But
So I'm not going to, like, you know. Okay, so basically, it is quite severe for people who legally considered Muslims. If they want to change their mind, then they.
As a general rule, yes. That's the summary. I mean, different theories, and in one theory, government and lawmakers have more power to suspend. If I were to make another argument just to justify the jurist, not to say justify it myself, but to say how the jurist might argue it, then yes, lying as a vice is not greater than publicly admitting sins, which is a greater vice. Because if we were all to go on Facebook, not what you said, but just if I do advice first of all, if we all went on Facebook to talk about our extramarital relationships and our exploitative trade and our this and our that, it makes these lifestyle choices. And part of maintaining this public space for the Muslim community is that vices should be secret, and the public imagination is close to the public imagination we're looking for. The greatest vice in this framework is to reject God after having believed in Him, or reject the faith after having accepted it. So it's just on that ladder. It's the greatest of these vices, and if people are shown it's a lifestyle choice, they can opt in and out, then from the point of view of the juristic community, we haven't preserved what this community requires, which is a preservation of the best ideal to ascribe to, and let vices stay private. That's the best I can say. And if somebody wants to make it public and be a martyr or the like, that's when they're going to clash with the law. But I fully appreciate what you're saying. It's the best way I can explain it in that frame. I can't say no more than this.
Making it public seems like, if you, to me, it seems like there's a difference between sort of marching down the street with placards in public and, you know, like law enforcement holding me down and saying, tell us, have you, like, do you think X, Y, Z? It's like, it's.
But now you've taken it to enforcement. Enforcement is again the space of lawmakers. The rule is it's an anti-privacy code, right? You shouldn't be entering people's houses, you shouldn't be doing inquisitions, You shouldn't be questioning anyone. This needs to go to court. And it only goes to court if there's that public expression. That's why it's tied to public disorder in a faith community where there's this need to uphold a public ideal. But that's the best that I can say. Enforcement is a separate question. Yeah, it's not satisfactory, but I'm just saying, we're just trying to understand as best as we can across traditions.